Buncombe County Criminal Justice 101. The adult criminal justice system in Buncombe County is complex and it can be tricky to navigate. This video is to help break down how it works. Let's start by looking at the agencies involved. The system is made up of many government agencies operating at the state, county, and municipal levels. Leaders of these agencies are a combination of elected and appointed officials, and each have authority and discretion granted to them by state law. The primary types of agencies include law enforcement, detention and corrections, and the courts. There are 2 criminal courts. District Court hears cases involving misdemeanors and infractions, while most felony cases are heard in Superior Court. Often, the first place that people interact with the justice system is at the time of arrest. What happens when someone gets arrested varies depending on factors such as the types of charges they face. Typically, it starts when an incident occurs and is witnessed by or reported to law enforcement. Depending on the seriousness and circumstances, officers have discretion as to how they respond. For example, in situations where the individual is in mental health crisis, officers might decide to divert the person to the behavioral health urgent care so they can access treatment. For infractions or low-level misdemeanors, an officer may issue a citation requiring they appear in court at a later date. If the officer makes an arrest, the person will be taken to the detention facility, also known as the jail, which is overseen by the elected sheriff. Once at the jail, the individual will have an initial appearance before a magistrate, who is an appointed judicial officer. During the initial appearance, the arresting officer will explain what they observed, and based on the information presented, the magistrate will determine whether the officer had probable cause to make the arrest. If probable cause is found, they will issue a magistrate's order which officially charges the person. At this time, the magistrate must also make a release decision. In North Carolina, there are several different types of pretrial release. If a person is released by a written promise to appear, they promise to appear for all court hearings while their case is pending and no bond amount is set. When a magistrate issues a bond amount but payment is not required to be released from custody, then an unsecured bond has been set. A secured bond requires a financial payment be made to be released from jail. Secured bonds can be paid by cash, bail bond company, or through the use of collateral such as property. Another common way people are released is to a pretrial program. The local pretrial services program allows for people to be released from custody and still be under some level of supervision in the community while their case is pending. After a release decision has been made, a first appearance hearing takes place in the courthouse. This is the first time a person appears before a district court judge, an elected official who has the authority to review bonds, conduct probable cause hearings, hear criminal cases involving infractions and misdemeanors, and take pleas for low-level felonies. For individuals who remain in the jail, their first appearance occurs by the next business day. At that time, the district court judge reviews the bond set by the magistrate and assures the individual's right to a lawyer. For those individuals who are unable to afford a lawyer, the court will assign a public defender to represent them. A public defender is a state-appointed position whose function is to represent individuals based on income eligibility in which there is a right to counsel, including individuals charged with misdemeanors and felonies, juveniles charged with delinquency matters, respondents who have been involuntarily committed. This office is comprised of full-time assistant public defenders, full-time investigators, and legal support staff. Appears as defense counsel for Veterans Treatment Court, Adult Treatment Court, and Sobriety Court. The judge must also notify the prosecutor if the charge against the individual is improper or defective. The prosecutor, or district attorney, is an elected official who is charged with the duty to represent the state in the prosecution of all criminal matters filed in district and superior court and to advise law enforcement in the district. Sometimes referred to as the DA, the district attorney has broad authority to press a case to trial as charged, to dismiss charges, to defer prosecution, or to offer a plea negotiation. The DA also has the authority to advocate before the court for appropriate pretrial release conditions to ensure public safety. If an individual remains in custody after their first appearance, a bond hearing typically occurs within 2 business days of first appearance. A bond hearing is another opportunity for a district court judge to review the bond and make modifications if deemed appropriate. If a person is unable to make bond, they'll remain in pretrial custody until they are able to make bond or their case is resolved. An attorney can request a bond hearing for their client at any point while a case is pending. If a person is released while their case is still pending, it is important they make all future court appearances. Failing to appear in court can result in an order for arrest and additional monetary fines. It's not uncommon for cases to be continued several times to ensure evidence has been processed and both the prosecution and defense are prepared to resolve the case. Cases involving infractions and misdemeanors will be resolved in district court unless a misdemeanor case is appealed for a jury trial in superior court. Most felony cases will eventually move to superior court for resolution. Until that time, felony cases will remain in district court. Cases in district and superior court are resolved by dismissal, deferred prosecution, finding of not guilty, guilty plea, or finding of guilt. If an individual pleads guilty or is found guilty, they will be convicted of the crime. The judge will impose a sentence which can result in time served, probation supervision, county jail, or state prison. If convicted of a crime, the person will also be responsible for paying court costs and could also be required to pay other fees such as restitution. These fees are collected by the clerk of court, an elected official who has a range of responsibilities related to criminal matters, including maintaining court records. Once the person has served their sentence, they will be released from state supervision. Buncombe County's adult criminal justice system is comprised of many governmental agencies, all of which are independent of each other. In an effort to ensure an effective and efficient system, criminal justice leaders formed the Justice Resource Advisory Council, which aims to promote collaboration amongst the various agencies. Buncombe County has several programs that assist individuals with justice involvement. These include 3 diversion programs, 4 specialty courts, and supportive programs such as career and education navigation and reentry services. For more information about these and other resources for justice-involved people in Buncombe County, please visit buncombecounty.org/JRC. This project was created with support from the John D. and Catherine T. MacArthur Foundation as part of its Safety and Justice Challenge, which seeks to reduce over-incarceration by changing the way America thinks about and uses jails.